Greetings, everyone. My name is Doug Atieh. On behalf of the Rutgers Center for Corporate Law and Governance and the Rutgers Institute for Continuing Legal Education, I would like to welcome you to our webinar series, the second of which is today, Dodd-Frank Reform of the Reform. Before we start, let me just mention that for those of you who have registered for continuing legal education, there will be codes in the chat that will tell you how to respond and get your credit. Also, just let me acknowledge before we start the financial and moral support that Bruce Ortwine has contributed to make this program possible. And also my thanks to Curtis Tao and Jarryd Anderson for organizing and assembling and putting together today's program. And with that, let me just turn the program over to our moderator, Jarryd Anderson.
Excellent. Thank you, Professor Atieh. Good afternoon, everyone. First of all, I just want to say thanks to Professor Doug Atieh, Rutgers Law School, and the Center for Corporate Law and Governance for hosting this very important, and what I'm sure will be a very interesting conversation. As an alum of this law school, it's always great to come back to Rutgers, even in the digital sense, and I'm incredibly excited to be moderating today's panel. As some of you may know, this panel was initially organized to be part of a one-day conference scheduled way back in April of 2020. However, because of the pandemic, we've been forced to transition from one all-day event to a three-part speaker series. We hosted the first part of this series in October of last year, where we took a retrospective look at the 2008 financial crisis and the Dodd-Frank Act. Today's conversation is part two of that series, where we hope to dive into a discussion of the reform of reforms and touch upon how they impact the current financial system. Keep an eye out for additional information on part three of our series, which will cover fintech and financial innovation. Now for today's panel. We have some of the brightest legal and economic minds in the world of banking and finance with us today, many of whom, like myself, have spent time in both government service and private practice. We have with us Anna Harrington, who is a Senior Vice President and Associate General Counsel at the Bank Policy Institute. Seth Carpenter, who is U.S. Chief Economist at UBS and former Acting Assistant Secretary for Financial Markets at the U.S. Department of Treasury during the Obama administration. Ben McDonough, Associate General Counsel at the Federal Reserve Board. Rina Sani, Partner in the Global Financial Institutions Advisory and Financial Regulatory Practice at Sherman & Sterling. Curtis Tao, also a fellow Rutgers Law alum, who is Managing Director and Deputy General Counsel at Citigroup, and Atieh, Executive Director and Assistant General Counsel at JP Morgan Chase. We'll begin our talk with each of our six panelists providing brief opening remarks, and then we'll pivot to a number of questions on everything from capital and market regulation to safety and soundness and the COVID pandemic's impact on financial institutions. I suspect that this will be a pretty free-flowing discussion, but I'll do my best to reserve 15 minutes at the end of our conversation for audience Q&A. So first off, let's start with Anna to provide her opening remarks.
Well, thank you, Jarryd and Curtis and Professor Atieh. I'm very honored to be here today and happy to see everyone is doing well and healthy. I'm going to talk about capital today, and my contention is going to be that maybe I thought about this too deeply, but that reform of reform in the capital space is yet to come. But let me go back a little. So as a broad policy matter, the last crisis, 07 to 09, was viewed in large part as driven by a deficit in the quality and quantity of capital at banking organizations, particularly large banking organizations. And we saw market participants really lose faith in the quality and measures of capital. So coming out of that, the post-crisis regime was really a response to that, and was a response to what was seen in the last crisis, and in particular, the Fed and other banking agencies work to enhance the quality and quantity of capital. And that's true both in terms of measures that look at risk and leverage measures that don't look at risk. Then adding buffers was key on top of regulatory minimums that are meant to govern capital distributions and incentive compensation payments. And then third, stress testing was really important to gauge banks' ability to withstand severe stress. A large part of this, you might hear Basel III, and a large part of this was done through reforms coordinated through the Basel Committee. The reforms from the get-go were tailored. So the 8 US GSIBs generally had the most stringent capital requirements. That's true today. You have several of them here on the panel. It's well recognized that coming out of the last crisis, the most important element was the regulatory strengthening of the amount of capital held by banks. As a result of those reforms, large banks have doubled their CET1 ratios from 2009 to today. So going back to where I think we were gonna, be talking about earlier on when we were planning this panel a few years ago. So in 2018, it was 10 years since the onset of the great financial crisis. The new leadership came in, and I think in recognition of how important the capital reforms were in reaction to the great financial crisis, they pretty much went on record right away saying that they wanted to maintain capital. The capital was a, quote, core reform. Tailoring was driven by legislation, but my sense is that was pretty modest in the capital space. So now kind of looking forward, and I really did want to get to today. So more than a decade since the Dodd-Frank Act and since the last crisis, you might be asking yourself, have we reached a steady state? Have capital reforms stopped? Have the increase in capital requirements finished? And so I think the short answer is no, they haven't yet. In particular, so in March of last year, shortly before the onset of COVID, the Fed finalized, what I think was meant to kind of be the culmination of the regime, stress capital buffer. So it establishes a new buffer at the bank holding company level based on firms' stress test results, and it also requires them to pre-fund 4 quarters of dividends. So it's based, the buffer, this new SCB, it's based on a very conservative stress test, and the entire point of it is to govern capital distributions in severe stress. I want to just take a step back, pause, thank the Fed. I think they deserve tremendous credit. They took a number of really important actions in the midst of COVID last spring. However, when it comes to the SCB, so it would have been effective October 1st of last year. It would have had its first wartime test, but instead the Fed imposed instead of relying on the SCB, the Fed imposed new restrictions on capital distributions, that's dividends and repurchases, when they announced their June stress test results last year. Those restrictions are still in effect today. The Fed has to decide this month, in March, by the end of the month, whether to extend those restrictions on the largest banks. Banks have performed well in 2 rounds of stress tests last year. They face a third coming months. By that time, the largest US banks will have gone through 7 downside scenarios, all told, since last June. Last week at a conference, the Fed Vice Chair for Supervision basically said banks were prepared for COVID. They would have been fine without these new capital distribution limits. And this experience shouldn't be repeated short of an asteroid flaming in the sky. That's my interpretation of what he said, but that's basically what he said. So it seems really hard that these statements can coexist with the restrictions being extended again, but we shall see. And the Fed has said numerous times that the banks are strong, that the financial system is doing well. And so, I think the best thing, if that's the case, to show faith in the system and to show faith in the framework that the Fed built, is to move to that framework. And so in terms of reform, that's the #1 issue today. Does the framework work, and does it work through the cycle? Leverage ratios, I just want to touch on that too. So there's another really key, a lot going on in capital this month. There's a really key decision. The Fed last spring deserves huge credit. They took steps to ensure that banks could continue to intermediate. In particular, they excluded deposits held at Federal Reserve banks, so basically cash and US Treasury securities, from the denominator of the supplementary leverage ratio. That's a new leverage ratio in reaction to the great financial crisis that includes off-balance sheet items in the denominator. So this encouraged banks to engage in low-risk, balance sheet intensive activities. I think it was hugely helpful in the midst of COVID. The Fed has to decide by the end of this month whether to extend that exclusion. So it's a big month and two really important decisions need to be made. It's very important that the Fed find a long-term solution to leverage ratios. With the projected level of reserves in the next year rising, it is very important that the largest banks are able to support the economic recovery. I think we've learned a tremendous amount in the past year about areas in need of reform. Leverage ratios is one, usability of buffers is two, and then pro-cyclicality, the idea of capital going up in times of stress. Those are all things that I think the Fed needs to revisit. In addition, the agenda this year, the most important item on the Fed's agenda includes Basel IV. So that's going to also include a review of other key elements of the Fed's framework, like the GSIB surcharge, which is direly in need of recalibration. Therefore, my contention is that the reform of reforms from capital is yet to come. Thank you.
Thanks so much, Anna. So I think at this time we will turn to Seth Carpenter for his opening remarks.
Excellent, thank you. And I have to say, I'm gonna follow up a lot in some ways on what Anna said, but through a bit more of a market's perspective on what's been happening. And also, as Jarryd noted, I spent time working as the Assistant Secretary for Financial Markets for the Treasury for that 15 years working at the Fed. So I've been part of rule writing processes. I understand the challenges, and I have to say we often hear criticisms of rule writing in regulatory areas as don't fight the last war or be aware of unintended consequences. And I think there's some validity to those, but I think sometimes they're overblown. So I wanted to talk a bit about that. I think, and this is consonant with some of Anna's comments, I mean, the intent of Dodd-Frank and the rest of the regulation was supposed to increase safety and soundness. The stress tests were supposed to come up with a system that would survive an adverse shock. And did we get an adverse shock? It was a huge adverse shock, the sort of adverse shock that literally no one would have anticipated. And the good news is the kind of systemic failures that we saw before did not materialize. I think the bad news is that massive intervention into markets by the Fed and ultimately by the Fed in conjunction with the Treasury was still needed. And so that to me says maybe all of the work is not done yet, not necessarily taking a stance as to should there be more or less, but just in terms of understanding the implications in the current circumstance of regulation. So, I do think sometimes the argument against regulation that we're only fighting the last war is a little bit overblown. When we're thinking about up until COVID, if someone accused you of fighting the last war, I think it would be pretty easy to point out that the last war was terrible. And if we can avoid having that happen again, I'm not really sure that's a bad outcome. So in and of itself, the argument, don't fight the last war, I think is a little bit vacuous. I think the problem comes in if you're only fighting the last war and that either keeps you from thinking forward about what the next war might be, or if there are these so-called unintended consequences. And I'm going to add a third variant that pulls these two together in just a second. So this shock was very, very different than previous shocks. The effects on the middle and upper end of the income and wealth distribution on large businesses was much softer, and in some cases actually advantageous than for the lower end of the income distribution, wealth distribution, and business distribution. And I suspect in many ways that explains at least some of why there was a differential effect on the financial market and the banking system. But nevertheless, I think it is very, very easy to overlook the successes that exist for the regulation that was in place. Now, unintended consequences can be real, even though it's something of a trite phrase that doesn't keep it from being a meaningful thought. In fact, the only way something becomes trite is because it gets used enough in actual context. And here, Anna's point about capital requirements, though, I think are very, very clear. And there is no question that higher capital requirements make balance sheet more expensive for banks. If you have to hit in the private sector a certain return on equity, and for a given amount of economic activity, you have to hold more capital, then those economic activities become more costly. That doesn't make it a bad thing. And in fact, the economist in me says, well, often there are externalities that happen in markets. And if you tax externalities in a way so that they are internalized, that's actually an efficiency improving regulation. So I don't think one can argue in and of itself, higher cost of capital is a bad thing. However, I think last March was a clear episode where some of the unintended consequences can come in. Now, eventually, as Anna pointed out, the Fed excluded both bank reserves and treasuries from the supplementary leverage ratio. But March, we saw a big blow up in the US Treasury market, what in principle is the deepest, most liquid market in the world. And yet at times there was no bid in the market. So dealers unwilling to make markets. And part of that has to do with the risk itself, the uncertainty itself, but also the cost of balance sheet. And here, this is where I start to wonder, okay, how much have we thought through what's been going on? Market making in treasuries is presumably pretty important. The Fed reacted quickly, changed the regulation by excluding treasuries and reserves from the denominator of the SLR. But I think the need to do that in such an emergency fashion sort of highlights why one should always be thinking through the implications of the existing regulations in case things go differently. So if we take that thought, is it okay to fight the last war? My view is in certain circumstances, yes, especially if the last war could get repeated and it doesn't keep you from thinking about other issues. And then the idea of unintended consequences, yes, they can happen. And so maybe there has to be a response. I think I would take those two thoughts, put them together and just, again, having been part of rule writing exercises in the past, I think the biggest risk we have when we think about regulation, or maybe not the biggest risk, but one big risk we have when it comes to regulation and new writing and revising regulations is insufficient creativity or imagination. And what do I mean by that? So the supplementary leverage ratio was always meant to be a limiter. It was always meant to be in the background. Risk-based capital, the intuitive way that makes sense is the more risky an asset, the more potential harm it has in the institution, therefore the system, the more capital should be held against it. But the supplementary leverage ratio and any non-risk weighted leverage ratio is just about pure size. And one could make arguments for whether banks should be bigger or smaller. But I say imagination was called for because even after the Fed's QE in 2009 through 2013, the highest level of reserves in the banking system was only about $2.7 trillion. Now we're at just over 3.5 trillion and well on our way to $5.5 trillion. Put in different terms, at the end of last year, bank reserves were 1/4 total assets of the banking system. Now, bank reserves are liabilities of the Fed, cash immediately available, no credit risk, no liquidity risk. And so when the leverage ratio itself becomes binding, what one is effectively doing is penalizing banks for holding the safest of all types of assets. And I'm not sure that was the intended consequence, but I also am very confident that no one at the time thought that there would be 3.5 up to $5.5 trillion of reserves in the banking system. I'm fairly confident at the time, no one thought that there would be, over the course of just a couple of years, another couple $1 trillion of additional treasury debt outstanding. And it's that sort of forward-looking extra imagination, thinking about the different contingent circumstances we could be in, that matters. So what do we end up with? Well, I think we end up with then banks rationing very low return balance sheet intensive activities like intermediating in the treasury market and operating in short-term financing markets, reducing liquidity there, which again, looking back to the previous example, those sorts of short-term funding markets were very much at the locus of the problem during the financial crisis. And so looking more creatively at the problem, if we what is it that we're trying to solve? And is there a version of the world where seemingly innocuous regulations like the supplementary leverage ratio that was supposed to be a backstop could actually be the first line, the binding regulation? I think thinking more seriously about those sorts of circumstances end up happening, and ends up having, potentially lasting effects. Disintermediation of markets can be a problem. Making balance sheets more expensive, like I said before, isn't necessarily in and of itself a problem. But in the context of an acute shock where the world changes reasonably quickly, there I think these frictions end up being reasonably large. Let me stop there and pass on to the next speaker.
Thank you so much, Seth. I guess, Ben, you're up next.
I'm up next. Thanks. Thanks, Seth. Thanks, Jarryd. Thanks, Anna. I'm going to do a slight detour and just to try to sort of pick up the torch that Seth was carrying forward. I'll just maybe mention a few things about his remarks. I couldn't agree more with what Seth said about not fighting the last war. And I'm sort of, and I also thought the way Seth was framing how to think prospectively about the leverage ratio was very helpful. And I can tell you that similar conversations are happening right now within the Federal Reserve, thinking about those very questions that Seth was asking. I'm happy to say that a year ago, we did not have to fight the same war that we fought in 2007 and 2008. We had a real world test of whether our financial system had become safer. And fortunately, we had good news. This time around, banks were able to serve as a source of strength and credit intermediation to the US economy, rather than a risk to the US economy. Banks had more than doubled their capital since the 2007-2008 financial crisis, and banks were holding approximately $3 trillion in high quality liquid assets. And that was, I can't tell you from the perspective of a regulator how happy I was as we were going into the crisis and knowing that we were going to have to take likely very special additional measures to combat the COVID event, that we weren't going to have to spend our times trying to simultaneously go out and try to raise capital for banks. So that allowed us to do a couple of things. That allowed us, because resources are limited, we were able to spend time doing other helpful things during the COVID event. And I'm not going to talk about, like, opening emergency lending facilities and doing other similar interventions. And it also meant that we were able to keep moving forward on making our regulations and our supervision more transparent and efficient. And that's what I'm going to spend the next few minutes talking about. So I'll start off by talking about, I think, what's commonly been known as Volcker 2.0, and that is the prop trading revisions to the Volcker rule that the board did in 2018. And there's three things about that I'd like to highlight. The first is that I think that illustrates the challenge of quote unquote right-sizing regulations. The original regulations that we did in 2013, I think came to be seen by many as potentially overly broad in their application, and tough on banks that weren't engaged in a tremendous amount of trading activity. And while the original regulations had some amount of tailoring, it was focused on size, not on the level of activity. And so one of the helpful things about Volcker 2.0 is that it focuses on trading assets and liabilities of a firm. And so that's a focus on specifically on the trading activities and therefore on the risks. Next thing I'd like to mention about Volcker 2.0 is it shows there's a lot of different ways to tailor a regulation. And there's two ways we did tailoring in Volcker 2.0. And as I think about tailoring, that's just sort of a loose term about trying to make sure that our regulations are attuned to the level of risk that's presented by the entities that engage in them. So the way we did tailoring in Volcker 2.0 was first, we tailored the compliance obligations relative to the entities that were subject to it. And we also tailored the definition of trading account to limit it to the activity that was subject to the rule. And then the last theme I'd like to mention about Volcker 2.0 is it's a theme that Vice Chair Quarles has mentioned before, and that is trust but verify. For the firms with the highest level of trading activity, the rule maintained the requirement that those firms report trade-related data to the regulators, and the measures don't indicate these measures don't indicate that firms resume proprietary trading activities after the rule was amended. So that's helpful. One of our obligations as regulators is to make sure that the rule is functioning as intended, and so far that's been the case. I'll switch now to Volcker Rule 2.1 and just mention a few things about that. That's the other side of Volcker. That's the covered funds part of Volcker. That's how at least I understand Volcker 2.1. And a key thing there was simplifications. First of all, we tried to improve and clarify the treatment of foreign funds, which had been a major source of concern, I think, particularly for some foreign banks operating in the United States. Second, we simplified and clarified the operation of compliance requirements in the rule, including by limiting extraterritorial impact to the rule. And third, we permitted banking entities to engage in certain fund-related activities that don't present the sort of risk that the Volcker Rule is intended to address. So that is that's Volcker 2.0 and 2.1. I'm not going to strictly follow the order you gave to us. I'm going to switch next to talk a little bit about tailoring. So in addition to that very specific form of tailoring, back in 2019 and then quite recently, the board's taken steps to tailor our capital and liquidity requirements as well as our stress testing requirements, what we call our package of enhanced prudential standards that apply to the largest firms. We introduced 4 categories of firms to differentiate them based on their risks. We did that on an interagency basis, and we did that based on data analysis. So to make sure that the risks that we were trying to address in our regulations actually matched the risks of the underlying firms. More recently, we made capital plan rule changes to what we call our capital plan rule. So that's the rule that undergirds our CCAR and stress testing processes. And we had promised, sort of pre-committed at the time that we did the final tailoring rule back in 2019, that we would make some special changes for what we call the Category 4 firms, so the least systemic of the firms subject to these enhanced prudential standards. And we finally did that recently, making some changes, for example, notably that lets them, if they want to, opt into the stress tests in off years. No obligation to do so, but they can. Sort of jumping now to FSOC. In terms of FSOC, I don't really feel like it's my place to speculate what FSOC might do in terms of non-SIFI designations. You'll find that regulators get shy when they get asked questions like that, especially when it's not even you, but a sort of a co-equal regulator. So rather than talking about what FSOC might do, I'm gonna mention a couple areas of vulnerabilities that I see in the system that are related to third parties. And the 2 key areas of risks I see, and I think that's been evidenced by some episodes we've seen over the last year, are cyber risk, first of all. Cyber risk has certainly been a focus over the last year, certainly as many of us are still at this work from home posture, and many banks are in the same situation. So we continue to remain vigilant on cyber risk, and that's sort of illustrated by the fact that we recently, with the FDIC and OCC, issued what we call the cyber notification rule. And that's a proposed rule that would require banks and their service providers to notify their federal regulator in the event of a cyber breach that met a certain standard. We're still out for comment on that, so not a ton I can say about that other than, again, to mention that it's an area of focus. And that brings me to the other risk and of ongoing focus, and that's the relationship between banks and their vendors and other service providers. That's another channel of vulnerability that I anticipate that we're going to keep focusing on in the near term. And then, Jarryd, I had a process question for you. I think I'm up next, so I can just shift to my next bit on FBOs, or I can turn it back to you for a moment.
Yeah, Ben, I think we'll probably turn it over to Curtis to go through his opening remarks, and then circle back to you in a bit.
Sounds great. Thanks.
Okay, thanks. First of all, thank you to everyone who's participating with me on this panel, and everyone who joined. I'll just make two, opening comments just for purposes of framing. First, for the law students who are here, I think this symposium, which is sponsored by the Rutgers Center for Corporate Law and Governance, really gives you a kind of insight as to the complexity of banking regulation. And it's an incredibly challenging and rewarding career as an attorney. There's lots of different aspects to it that you can engage in, whether you're in the private sector, working for a bank in-house from a regulatory perspective, or as a regulator, or working at an industry group, or frankly, serving as an economist. So I think the opportunities that you have through the center are terrific. And what I'm going to talk about is enhanced prudential standards focused specifically on governance and risk management, which is squarely in the wheelhouse of the particular center. The other framing comment I want to make is that we've talked about the reforms which came out of the Dodd-Frank Act, and absolutely right, as Anna, Seth, and Ben have said, how do we kind of avoid the issue of kind of fighting the last battle? But we can't forget the last battle because it was such a significant event. There are lessons learned, and those lessons really did inform what was in the Dodd-Frank Act. And some people may think that the reforms that were implemented and then the changes to the reforms were all about scaling back, right? You had to change an administration, you had new regulators, and it was just about pulling back. Not so. Don't forget that the banking agencies are very much in large part by structure and by tradition, independent agencies. And speaking on behalf of a large US bank, many of you may not know this, but there are 8 designated US banks, which are globally systemic institutions. We didn't see a lot of changes. We did see refinements. We did see tweaks. And that's the right thing to do because you create a rule, a law, the Dodd-Frank Act, and you create a rule and regulations to implement that. And you do the best you can, speaking on behalf of the regulators. But over time, you need to make sure that those rules can evolve. And one of the things I'll talk about as to how that has evolved, speaking first about where we began, is with respect to risk management and governance. There certainly is a view coming out of the financial crisis that you had these large banks that really screwed things up. They are so integral to the financial system and to the economy that their failure or their potential failure can create havoc for ordinary Americans, Main Street businesses, and that is certainly evident in 2008 and 2009. So there are a number of failings that I think the regulators and policymakers thought were cause of that. And so they created tools in the toolbox. Anna and Seth talked about capital, right? More capital is a key tool, but obviously you need to balance that because the more capitals that banks hold, the less capital they can deploy to allow the economy to move and to function. Another tool is some of the things in the prudential changes and reforms that Ben talked about. Liquidity as well, and now I'm going to talk about governance and controls. It is certainly my view, and I wanted to say that I express the views on behalf of myself and not necessarily are the same views of my firm, that the financial crisis was in part because of a failure of risk management and risk management governance. And you can certainly say that for certain industrial companies, you allow Delaware corporate law and the duty of care and duty of fair dealing and loyalty to govern. And if there's anything that goes wrong, well, you have private rights of action. Well, you know what? For banks, banks are special and its affiliates are special. They have a special place in our economy. For US banks, they're supported by taxpayers via the FDIC fund. So you need to be more prescriptive because you can't allow the slow process of the private sector to correct failings at a particular bank, because if a bank goes down, particularly a large one, it can cause, as I said, havoc with the financial system. And so what you saw in the Dodd-Frank Act, you had the implementation of Section 165, which relates to enhanced prudential standards. A key aspect of that, one of many, Rena will talk about some other core reforms that are in 165, is risk management and risk governance. The Fed, the Federal Reserve Board, did issue rulemaking in 2014 implementing Regulation YY, a number of different aspects to it. So if you think about how the Fed thinks about what were the kind of key tools that they needed to focus on. Key failings, capital planning, liquidity risk management, and risk and controls. 225.33 involves risk and risk management. That's the Fed's perspective. The OCC in 2014 issued very similar rulemaking, was guidance, but they considered this guidance to be of a special stature. It's called Part 30 and heightened standards, also talking about risk management, governance, and responsibilities of senior management and the board. What I'm going to say now with respect to, well, what are the reforms of the reforms? Well, I think embedded in those rules are principles, but the principles are malleable. They have to evolve, because I will certainly say that banks today are different than they were in 2008 and 2009. The markets, the financial system, the banking sector, the products which are being offered are different than they were. And so you need to have these rules which can change. But what are the governing principles that allows you to change how you manage a bank in a business environment and market environment today, as well as it was, let's say, 10 years ago? Well, I think here are the kind of governing principles. You've got accountability, responsibility, oversight responsibilities of the board of directors. Scout Alvarez, the former general counsel of the Federal Reserve Board, used to say this: you need the board to provide adult supervision, right? And there's a number of kind of concepts within corporate governance that you think about, what does the board need to do? And it's a balance. And one concept is this: noses in, fingers out. The board provides oversight. You need to make sure that they're not doing the day-to-day because they don't have the capacity or the time. If they're providing oversight, you can't do day-to-day, but you have to be accountable. And so, of course, if the board doesn't provide appropriate oversight, there are going to be consequences. And they need to implement and they need to install capable, talented, and accountable senior managers to execute upon the strategy which the board will oversee. Next level of responsibility is senior management, accountability, oversight, responsibility, right? Those are the concepts which are embedded in these rulemakings. And then, of course, you've got management overall, the entire institution. And if you look at these large banks, which move trillions of dollars a day through our financial system, they have 200, 300,000 employees. Certainly in the US, there are institutions overseas which have even more employees. So how do you kind of divide kind of conceptually what management actually needs to do? Well, there's a concept that the OCC articulates, which many of us abide by, whether a US firm by analogy outside the United States as a foreign firm, which is one, the business, it's called the front line, right? They execute the controls as the frontline responsible business for the activities. Second concept is that you have the second line, which generally would be considered independent. That's independent risk and independent compliance risk management. Then they challenge, they review, and they're independent from the business. And then you have what's called the third line, which is independent or internal audit. They review, they test, they also challenge. All of this structure is then supported by what's called support and control functions. Legal, let's consider that, but we are all responsible for challenging the front line and ensuring that the franchise of the institution is protected. All of these kind of concepts are embedded in how we operate and how we organize ourselves. And that certainly has been a new structure post-financial crisis. Some folks would say that we've done this for quite a long time, but there certainly is a much different level of vigilance and organization to how we think about proper management, proper governance, and proper risk management. And again, this is just one of the many tools that have been really the focus of the Dodd-Frank Act in 165 and the reforms, and now the evolving reforms. With that, let me turn it back to you, Jarryd, and I think Rena will talk about some of the other tools from the enhanced prudential standards perspective.
Fantastic, Curtis. Thank you so much. So I think we'll pivot to Rena, and then Jay will follow.
Great. Thank you, Jarryd. So first of all, thank you to Rutgers Law School for organizing this series, and to Professor Eakley and Curtis and Jarryd for organizing and moderating the panel. It's a delight to be here with you today. So as Curtis mentioned, I'll talk a little bit about a couple of the specific enhanced prudential standards coming out of Dodd-Frank. And I think it sort of is an interesting counterpoint to some of the points that we've been discussing on reform of the reforms, because in many ways in these areas, I think that the regulators have been sort of more iterative and more sort of responsive in developing the requirements and the rules that apply as the requirements have been implemented. So specifically, I'll talk about a topic that's near and dear to my heart, which is recovery and resolution planning. This is sort of a response to this question of, too big to fail, and whether the financial institutions, or at least the largest ones, were too big to fail in the last financial crisis. I think a number of the speakers have been talking about specific reforms that have applied to the institutions in terms of shoring up capital and risk management and the other requirements of the bank. But this is really focused on sort of what happens in a scenario as in the last financial crisis, when it's perceived that some of those things have failed or kind of not managed to prevent a situation that imperils the institution, and whether the financial system is set up in a way that allows those institutions to be resolved or somehow put into an insolvency in an orderly manner. So just kind of rolling back the clock and going back to the New York Fed's rescue of AIG, and then the decision to allow Lehman Brothers to fail, there was a real concern and frankly, kind of a popular criticism that the largest, most significantly important banks were too big to fail because the failure of those institutions would have sort of not just an impact for themselves, but a significant knock-on effect for the financial markets in the US and globally, and to financial stability, both because of the way in which they operate sort of critical financial infrastructures in this country, and their sort of centrality to the access to capital for the markets. So that level of interconnectedness and interdependency sort of, in theory, undermined the ability for those institutions to be put into insolvency or bankruptcy, which weren't really well equipped, at that time to manage sort of that large scale institution and the potential cascade effect from those insolvencies. So it's against that backdrop, really, that the Dodd-Frank Act included a requirement in Title I for SIFIs with 50 billion or more in global assets to prepare what were called sort of Title I resolution plans, or more commonly referred to as living wills, which would be sort of documents that would show how those institutions could be resolved without significant taxpayer support in an orderly manner. And so the requirements in those resolution plans really did sort of focus on, how do you manage the interconnectedness within the institutions and with other financial institutions to minimize the impact of a failure? How do you sort of contend with the local insolvency regimes, because these institutions are international and therefore operating in a number of different jurisdictions under a number of different insolvency laws? And how do you sort of allow for continuity of the critical services that those institutions provide? So as I mentioned kind of up front, what was interesting about that process, kind of having lived through it, is there was a real iterative sort of nature to the requirement and to what the regulators were putting out and to what the institutions were submitting. The Title I resolution plans were ones that were submitted and prepared by the institutions, and then as the institutions became more educated about what the expectations of the regulators were, and the regulators became more educated about what those plans look like, there was an ability to kind of develop the requirements over time through guidance. Now, the guidance itself is something that has been an area of focus in terms of reform, and we can come back to that at the end. But I think that has helped for this to be a process that's been sort of more iterative, and therefore sort of evolving over time, as opposed to kind of having an initial set of requirements and ones that need to be revisited with subsequent administrations. In addition to Title I resolution plans, the Dodd-Frank Act also imposed or put into place a new resolution regime, which was Title II, or the Orderly Liquidation Authority. And Title II is really modeled on the FDIC's receivership powers in a bank insolvency, but in this case, applying those to non-bank financial institutions, so that a bank holding company, for example, or a large institution that was engaged in financial activities, but that's not overseen by the FDIC, could be put into a receivership upon the recommendation of the Treasury Secretary, with the appropriate vote by the Fed governors, with a receivership that then would be administered by the FDIC. And so while the banks were busy preparing Title I resolution plans to submit to the Fed and the FDIC, the regulators were in their own turn preparing Title II resolution plans to show how the resolution under Title II would be administered with sort of minimal disruption in the same way that would be required under Title I resolution plans. What's been interesting again about that process is that over time, that's kind of led to the development of common resolution strategies in many ways in the form of a single point of entry resolution strategy. The idea being that in the event of a sort of financial institution insolvency or crisis, there would be a way to put the holding company, taking advantage of sort of the unique way that in some ways unique way that financial institutions in the US are largely organized. There would be a way to put the holding company into a resolution proceeding and allow the losses to really be absorbed by those holding company shareholders and long-term debt holders, while allowing the operating companies that largely sit underneath that holding company, whether it's the insured depository institution or the broker-dealer or other of its operating affiliates, to continue to operate sort of with minimal disruption in the event that there's sort of a severe loss or market disruption event. And that single point of entry strategy has really been adopted in sort of a number of different jurisdictions and has led to, some of the capital and other reforms that others have talked about or will talk about. So that's kind of an interesting and sort of really largely contained requirement within the Dodd-Frank Act. I think, a couple of the themes that have come out, through that process and in that rulemaking, which you still see largely kind of resonate today and is sort of still an area, I think, of ongoing discussion, is this question of, the large nature of these institutions and how interconnected they are. If this regime really sufficiently answers the challenges of that. But I think on the counterpoint, you do see sort of, especially from the last crisis, the advantages to having those kind of large and interconnected institutions and the way that they help to manage liquidity into the financial system in challenging circumstances. A second sort of significant theme was the international nature of these institutions, and again, whether that has been sort of a challenge that has been sufficiently addressed through the resolution and recovery planning process. And I think that, international sort of cooperation and coordination has been one of the real significant benefits of that resolution and recovery planning process. I think we still have what Ben referred to as trust but verify, and maybe Vice Chair Quarles has most recently referred to as trust everyone but brand your cattle, in the sense that there's still, a lot of focus on how do you make sure you have your adequate liquidity and capital in the jurisdictions that you need them when you need them, but that there is, sort of certainly a much better coordinated infrastructure in place for the next financial crisis internationally. And then lastly, this point about kind of how institutions continue to provide critical operations and infrastructure, I think is, again, something that we still, it's still a focus on. And as, we have even further reforms of this reform, there will be continued focus on, do we have that liquidity positioning requirement quite right? Is that sort of an overarching sort of limitation that's more constrains the institutions than it does provide flexibility? And how do we think about, whether some of that guidance that has been the way in which these requirements have been put in place, whether that needs to be subject to more sort of comment and notice rulemaking requirements. So I'll just pause there and turn it back to Jarryd.
Excellent. Thanks so much for that, Rena. I think before turning it over to Jay, for those tuned in, I wanted to provide you with the CLE code. So the first code here is rules. It is not case sensitive. It's RULES. So CLE code 1, rules, RULES. And then I'll turn it over to Jay.
Thanks, Jarryd. I want to also thank everybody for the opportunity to speak. I think it's a fantastic topic, and although it's a year later, it's still a very timely topic, as you'll see from my remarks. I'm here to talk about derivatives. Derivatives, in particular, swaps, were regulated as part of the Dodd-Frank Act in response to the 2008 financial crisis. We've heard a lot about the regulation of banks and them being one of the aspects of the financial crisis that needed to be addressed: the capital, the risk management, the oversight, the regulatory framework for them. Another aspect of Dodd-Frank that was also blamed for part of the financial crisis was the regulation of bilateral swap products. These were products that two counterparties could enter into at any given time and agree to any terms that they see fit. They could be for large amounts, as we saw in the 2008 financial crisis with AIG entering into CDS transactions on very large notional amounts that they thought at the time were particularly safe, but turned out to expose them to high losses. There weren't very many capital requirements or transparency requirements prior to Dodd-Frank. Dodd-Frank required the SEC and the CFTC to implement a new framework for the regulation of swap activities. In many respects, it's been actually a great success, at least in the CFTC side. On the SEC side, they have yet to fully adopt a lot of their framework. I think they've adopted most of it, but it doesn't come into effect until the end of this year, which we're 11 years after Dodd-Frank. So I think one fair criticism of Dodd-Frank was that the SEC and CFTC were still two different regulatory bodies, and you'll see two different regulatory approaches with respect to the same product. You have the CFTC regulating swaps that don't reference securities, and the SEC referencing swaps that do. Two different frameworks, similar in some respects. They're required under the Act to be similar, but different in a lot of respects in terms of when registration is triggered, what can comply with the capital margin requirements, what can you do for the disclosure requirements. And firms like ours and like a lot of the swap dealers and major swap participants out there are now subject to two separate regulatory regimes for the exact same activity. So while I'll get into the successes in a second, while there have been a lot of successes with the derivatives market, there have also been a lot of drawbacks, which is we still have two separate regulatory regimes that now aren't necessarily consistent when, for all intents and purposes, they are basically the same product. So I think that is the fairest of fair criticisms, and one that may be addressed in the future or may not be. In terms of the great successes, there've actually been a lot of successes. So what Dodd-Frank required was that derivatives activity, both the people who deal in the derivatives, so people who are actually providing market liquidity, are subject to registration and regulation by the SEC and CFTC respectively, as well as the major participants, those that use derivatives for hedging purposes, for example, also register with the SEC and CFTC. They impose certain margin requirements on derivative transactions. There's a mandatory clearing requirement for standardized derivatives, such as CDS. That means that CDS transactions have to be facing a central counterparty, so that eliminates the bilateral credit risk between the two counterparties. There are registration, transparency, reporting requirements, all on derivatives activity. And we've seen in the past 10 years, this actually provide for a standardization of derivatives. You've seen a great reduction in risk, in my view, to the financial system. You have transparency on derivatives products. You have standardized margin for transactions. You have mandatory clearing for transactions. And you've seen derivatives sort of swaps in particular, taken from the behind the scenes transactions that you saw before 2008 into the forefront as a more standardized, commoditized product. Since the adoption of the rules, though, there have been some tailoring, playing along the theme that we've heard from some of the others. One of the key aspects of the Dodd-Frank Act is the requirement to post margin between two entities, two swap dealers. If a swap dealer is engaged in derivatives activities, they have to post margin. When the Fed, the OCC, and the FDIC, which govern the swap dealing activities of banking organizations, adopted the swap margin rules when they initially came out, they required margin between two affiliates in the same amount as a margin that would have been required in third parties. In a lot of sense, this didn't really make sense. You have two affiliated entities, they're part of the same regulatory framework, they're overseen by the same regulator. Having to trap liquidity between themselves didn't really make sense in a lot of ways. From a regulatory standpoint, it sucked liquidity out of the market, it tied up assets, it was expensive in a lot of ways. They're subject to the same risk managers. Recently, the regulators removed this requirement in some circumstances, and I think this was a helpful case of tailoring after looking at the rules and seeing that they didn't work as intended. The SEC obviously has not adopted the rules, so all the rules you've seen from the CFTC, where they've adopted everything and tailored it after the fact, the SEC is just starting. So we haven't actually seen the effect of the SEC's rule, which, again, going to my earlier points, is, I think, a very fair criticism of the split regulatory framework between the two. Looking forward, and one other thing I was going to mention, and I'll leave it so we can get to remarks, was one of the first criticisms you received of the Title VII regulatory framework was that it was going to be burdensome, it was going to be costly, it was going to make the US markets be at a competitive disadvantage in a lot of cases. And I think in some instances that was true. So the inter-affiliate margin was the one area where it was expensive for US firms. However, despite the criticisms that all the activity is going to move to London, people are going to try to flee the US regulatory framework, you're actually starting to see other jurisdictions copy the Title VII framework and in fact surpass it in some ways. So a couple of years ago, Europe adopted their own framework. It's known as MiFID II. It's similar to Title VII in a lot of ways, different in other ways, but it builds upon this framework that derivatives activities should have some regulatory oversight, that there should be some standardization, there should be capital requirements between entities, there should be somebody looking at derivatives activities because they're important to the markets. They're important to firms that utilize them, and that's why you see other jurisdictions adopting them, notwithstanding the initial concerns from them that this was too burdensome. And I think in the future you'll see some tailoring, you'll see some standardization. But I think what Title VII has primarily shown is that derivatives are important and that they can help a healthy economy function in a number of ways. With proper oversight and tailoring. You'll see the OCC, for example, on the banking side, came out with a new revised framework for national banks engaging in derivatives activities, sort of building upon this transparency and consistency model, providing a standardized framework for licensing for derivatives activities. I think you're going to see in the next couple of years sort of the same thing as the frameworks mature for the most part. But I think the short and long of it is Title VII, I think, is mostly successful in a lot of ways, given that it's mimicked outside of the US, though a lot of the deficiencies have been addressed since then. So the tailoring that I've mentioned, the one caveat being the slowness of the SEC.
Excellent. Jay, thank you so much for that. So at this time, I think we're going to open it up to our panelists and just tick through a number of questions that we think will be most interesting and fruitful to sort of add to this discussion. So the first one I'd like to kick off is just a focus on FBOs or foreign banking organizations. So one of the most notable changes in the US financial industry post Dodd-Frank has been sort of the presence of and operations of foreign banking organizations, or how those have changed. We've seen a few foreign banks start to reduce their US operations and activities, including Deutsche Bank and Credit Suisse. So what is driving that? What makes foreign banks different than U.S. banks and how they operate and how they're regulated in the U.S.? And I think an add-on to that sort of framing question, which continues along the same thread that Jay raised, is in the derivatives context of foreign regulators sort of copying the U.S. derivatives framework, is how has the U.S. played a leadership role in the post-crisis regulatory world with respect to how they treat host institutions that have sort of a presence here, and how foreign regulators have somewhat copied that for U.S. banks to have a presence in those host countries. So I'll look to Ben to sort of lead us off in his initial thoughts on this issue, and happy to get others' input. But Seth and Jay, I know that this is something that you guys have spent time focusing on over the years, and also would love to get your remarks following Ben's.
Thanks, Jarryd. I'll try to be brief to leave plenty of time for my co-panelists. I think one of the reasons why the U.S. has been seen as sort of providing leadership on this is we took a sort of a fair and consistent approach to foreign banks as we took to domestic banks when we were thinking about tailoring. And we've been trying to be, we have been honest with ourselves about the fact that the largest FBOs have substantially decreased their systemic footprint in the United States since the 2007-2008 financial crisis. And I think that shows up in a couple ways. That shows up in the fact that their tailoring categories are generally lower. It also shows up in the fact that we've recently updated our LISIC portfolio to remove the FBOs. They're just not as systemic and as scary as they used to be. So that's a good thing. And it's not that we're not continuing to supervise those firms. Those firms are now being supervised out of our LFBO portfolio, which is sort of the next tier down so they're being supervised alongside firms like well, I don't like to say firm names, try to avoid to do that, but similarly sized firms. I caught myself there. Well, the last thing I'll mention before turning it over to my colleagues is earlier this week, the Federal Reserve Board's General Counsel Mark Vanderweide mentioned that we're still thinking about doing work on branch and agency liquidity requirements. So there'd be branch and agency specific liquidity requirements. We introduced that idea in connection with the FBO tailoring proposal back in late 2018. We didn't include that as part of the final tailoring rule because we wanted to have further discussions with our international and domestic counterparts about that. This is, I think, again, one of the reasons why we're often looked to for leadership is we try to coordinate and sort of think together, get input from our counterparties. And as my boss Mark said, that particular work on branch and agency liquidity is still on the quote unquote stovetop. And I'll kick it back to you so my co-panelists have a chance to also weigh in on this.
So I'll highlight one sort of way that the FBO question manifests itself in markets. So there's often differential details to some of the regulatory implementation in different areas. So two specific examples. There have been times when, especially some of the European banks have been subject to some of the snapshots of their balance sheets being done at month end and quarter end, as opposed to the largest banks in the US being now having lots of reporting that gets done on a much more continuous basis. And what that can end up meaning is that you see big swings in terms of some balance sheets getting bigger in the middle of the month and then trimming down at sort of the snapshot period. And that had historically led to sometimes lots of volatility at those month end and quarter end periods, and sometimes big dislocations when because of the asynchrony of the regulation. And so I have to admit, part of my daydream about regulation, how regulation gets done, comes down to stupid mundane details like why should the 31st of a month be any more important than the 12th of the month or the 18th of the month? And having everyone sign on to that, I think, is important. And similarly, because the US dollar is, like it or not, for better or for worse, and I won't speculate for how many more years it will be, but it is for now the reserve currency of the world. The vast majority of trading gets done in dollars. Lots of foreign entities want to have exposure to US dollar denominated assets, and many FBOs don't have the same sort of organically grown retail and sort of structural business here, but they still want to invest in dollar denominated assets. And so when taken together as a company, they have to hold liquidity requirements by their home regulators, often in the specific currency where their assets are. It means that an FBO that maybe doesn't have the same general footprint overall, and as a result doesn't have the same natural inflows of central bank reserves, for example, has to hoard a little bit more aggressively. And so what that can mean is when you go back a year and a half, 2 years, when the Fed was shrinking its balance sheet, which seems like so long ago, and reserves were starting to get a little bit scarce, there ended up being these very intense pinch points because of the sort of, again, it's a bit of a mismatch because the way US dollar denominated assets are sought globally. And if the liquidity requirements don't sort of take that into account, it really can create these frictions.
From the perspective of a US bank who operates outside of the US, I do think you do see a lot of copying of the Fed's framework for FBOs. One of the criticisms that the Fed received when they adopted the IHC requirements and sort of the enhanced requirements for some FBOs was that US banks would begin to be subject to similar requirements outside of the US. And some of that is starting to be borne out. FBOs went through a pretty painful process of reorganizing all their subsidiaries under a intermediate holding company. Europe has adopted the same standard for large GSIBs and other large banking organizations. Now, for the European operations, you have to put them under an EU IHC. So there's a central EU entity that can be regulated. You're also starting to see some copying of the US's approach to things like internal TLAC and capital requirements, sort of starting to apply those in the same manner that the US applies to foreign banks, also applying them to US banks. And I won't go into whether or not it's justified or great for the financial system, but I do think it's something the world should take a hard look at on a coordinated basis to make sure we're not trapping liquidity, we're not trapping capital in large firms that may want to move it from one jurisdiction to the other. If every jurisdiction has a subsidiarization requirement, you may end up with a lot of trapped liquidity and capital or shrinking in jurisdictions. And whether that's the appropriate result is one for, I think, everyone's debate.
Thanks, Jay. So I think just switching gears a little bit, I'd love to get the thoughts from Rena and Anna and Curtis. Following the financial crisis, there was a huge debate around whether certain institutions, the 8 institutions that Curtis had outlined as global systemically important banks, were too big to fail. And the regulatory response to that and Congress's response in part with increased capital requirements and the need for resolution plans were part of the measures that were taken to try to sort of fortify the risk of those firms failing and causing catastrophic damage to the US financial system. So in the news more recently, and just from time to time, we hear instances of large banks running into trouble, sometimes from an operational perspective. And this has led to a debate among members of Congress and policymakers about whether large banks are too big to manage. So, I'd love to get the view from you all, given your support of these types of institutions, or your work on a day-to-day basis with them, or being within those institutions, on how Dodd-Frank has helped to shape that debate and just your general views.
Jarryd, I don't know if you want me to kick that off. Sure. So it's a great question, and I think that certainly, as you say, there are developments or hiccups from time to time that raise concerns or questions about how large institutions can be sort of appropriately overseen, and their risk management functions internally. and some of the, sort of oversight that is required. I think what, one can say in response to that is certainly, I think what we've also seen is the resiliency of those organizations in light of those, arguably, inevitable hiccups. And so the question isn't necessarily, are they too big to manage, but really, what is the right sort of way in which to kind of have oversight and management of those institutions. I think that, what Curtis mentioned in terms of, the increased focus of the board's role in overseeing the operations is a critical part of where the regulators are headed. And I think we'll continue to see, focus on that aspect of things. I think the respective roles of legal and compliance have been a topic that the regulators have been very focused on in connection with, sort of this issue of management of large institutions. And that's something that, I'm sure we all have thoughts about, but is an area that I think we'll continue to see the regulators focus on and the institutions themselves sort of focus on. So, I think that there's certainly, there's certainly issues that raise concerns, but I'm not sure that, what we've seen so far kind of fundamentally questions, the validity of those organizational structures, especially in light of sort of, like I mentioned earlier, the significant kind of critical operations that they perform.
Jarryd, let me also try to answer this with two broad observations. There's no doubt that the TARP legislation from the financial crisis is having and continues to have a lasting political impact. I would postulate this, is that if during this particular economic crisis, you actually had an aspect of the financial rescue packages, which I think amounted to $3 trillion plus, that needed to go to, let's say, banks, I think you would have probably seen a much different political kind of calculus. What we were very fortunate for here in this occasion is that there was bipartisan support for the substantial stimulus that did get injected earlier in 2020. And what appears to be the case that will be get injected, the $1.9 trillion package now. But I think banks, have a different kind of political appeal or distaste, I think, in the public's mind. And so then I think the second observation is, how do you have we created a regulatory regime that it's not just about resolving banks when they get into trouble, but it's about preventing banks from getting into trouble. So they've got that resiliency, exactly as Rena said. And how do you prevent the contagion from spreading to other banks in the financial system and frankly to the broader, economic and markets? The other thing I will also say is that before we answer, and I will at least provide my view, whether or not banks are still too big to fail or too big to manage, we have to answer the question, why are banks of the size that they are, right? Because I think many kind of ordinary Americans will ask that. Many ordinary Americans will ask Atieh, why do you have derivatives? Why are banks even engaged in that type of activity? Well, I think that the fact is that the clients, the marketplace require us to transfer that economic value throughout the system, something that people may not know. My institution alone moves $5 trillion a day through the financial system. What we are engaged in is both liquidity and tenor transformation. You take a deposit and then you lend it out to another borrower. That's the basics of banking, right? We move money through the system. There's not a lot of banks, there's certainly not a lot of US banks that can be the bank to the US Department of Defense when you think about the service people and the cash management needs that they have around the globe. US multinational corporations and the needs that they have for not only cash management, but also they need to hedge. And in order for them to manage the price, market, credit risk, they need derivatives. It's a financial product. It's the 21st century form of a loan that we banks intermediate. And so in order to support the economy of the size in the corporations and participants of the size that exists in the US economy, everything from everyone's 401k plan to the IRA, right? All of that require banks to have a certain amount of size and girth. There are certainly, opportunities for smaller banks, community banks, but there is a need for banks of a certain size and scope, and that's where we are. Now, have the reforms proven that banks are too big to fail, that if you had a failure, the system can survive without the contagion? I think, remains to be seen, but I gotta tell you, I do think that these reforms are broad. They touch a number of different areas. It's not just about recovery or how do you resolve. It's about governance, capital, liquidity, credit risk, market risk, right across the board. And then are banks too big to manage? Well, when you've got an institution that is global in scope, over 200,000 employees, you will have challenges. There's no question. If you're an industrial company, a manufacturing company, or a financial institution, but you need to make sure that you have that continued vigilance, which is why on the governance, the risk management effectiveness question, that is not only of a tool of regulations, but it's the tool of on-site supervisory examiners and the process, right? We are constantly getting challenged to improve, to be better across the board, across all these different areas. So it's embedded in the regulatory, framework. It's also embedded in the concept of bank supervision and prudential supervision. So I think there will continue to be evolving challenges. It's always something that you need to aspire for, but I think we are certainly in a much better place than we were 12 years ago.
Very, very quickly, just 2 housekeeping items, and then I'm going to turn it over to Anna. The second CLE code is reform, REFORM. Again, the second CLE code for those who need it is reform, REFORM. And for those viewers who are interested in submitting a question to the panelists, please feel free to do so now by using the Q&A feature. Anna, sorry for cutting you off. Please continue your thought.
No worries. So look, if you look at the stated purpose, go back to the GSIB surcharge white paper in 2015, that, addressing too big to fail, that was one of the intended purposes. You go back to the rationale of TLAC. The purpose of that is to ensure that the GSIBs could bear the cost of failure. So, the reform framework addresses these concerns. And looking, I want to take it back to capital in particular. So there's a range of studies on the optimal level of capital. And, I'm pretty comfortable saying that the largest banks fit squarely within that range. I'm not going to, reel off a bunch of numbers here. And then if you take TLAC into effect, they're at the top end of the range under conservative assumptions. I think it's worth pointing out on this panel today that the capital ratios of the largest banks, the ones that are stress tested and subject to the distribution limits in large part due to those limits, are higher today than they were a year ago. They're higher. They're better capitalized than they were a year ago. And yet the Fed principals have been saying for since at least 2017 that capital levels are about right, but capital levels are on the rise. So I think, a big question kind of on minds right now is what levels are about right? 2017, 2019, 2020, or today's level, which is, 12.8% versus last year was about 12%. That's from the vice chair's speech last week. So I think it's really worth taking a step back and saying, look at all the reforms we've put in place, the TLAC rule, the swap margin rule that Jay was talking about, single counterparty credit limits, all these rules, and asking are they really calibrated? Take the GSIB surcharge. Is it really calibrated correctly today for GSIB systemic risk? And the same thing, I'm really focused on risk-based measures, but the same thing applies to leverage. And I want to go back to what Seth was saying, because I think that's really important. We had a piece just come out that looks at over time risk-weighted measures versus leverage measures of capital and estimates what the SLR should be today. And I think, that's a really important thing for the Fed to be thinking about when they're thinking about recalibrating leverage ratios. Another thing, I worked in an FBO too, and I just, I think if the Fed is thinking about the regime in total, the pre-positioning piece is something that shouldn't get lost. Marina brought up the brand your cattle speech, and part of that was rethinking internal TLAC. And if the Fed is being a leader here, the thinking about moving the calibration there, I think is a really important point. Also on the FBOs, I think the LISIC piece was well appreciated, but there are other elements like the GMS that may deserve some further consideration. But I think broadly, we just went through a major shock, a shock that was like completely unanticipated. And the banks not only withstood an extreme shock, but they performed well and supported the financial system. So, I'm pretty comfortable with where the banks are after that experience.
Seth, please feel free to jump in.
Thanks. Yeah. So I think I agree with everything that at least is the implicit analysis and analytics of what was just said about too big to fail. I guess if just to throw a cautionary tale, and I don't think it actually comes down to the letter of the law regulation or what the standards are. It comes down to the day-to-day practice and the implementation. Should we be in a situation where one of these firms is big enough? So you could imagine, TLAC gets bailed in, the entity has enough capital to withstand things. I guess for me, one of the key questions, and we tried to work through this when we were thinking about orderly liquidation authority and how those sorts of resolutions might happen. I think there is a very, very critical exercise that could get done that would make me have more confidence in the system, which is lots of regular tabletop exercises with everyone involved. And how would it happen? How would we make it happen that the operating subs continue to operate, and what is necessary so that the counterparties would still have confidence in that sort of trading? So if we tell everyone there's enough capital, we tell everyone there's enough TLAC to get bailed in, that's great. But I suspect there are a non-trivial number of portfolio managers, a non-trivial number of money managers who would say, no, that's all good. And they can be the counterparty for the next guy because I'm taking my position out tomorrow or as soon as I possibly can. And so, do we have the right personnel in place to come in and have the voice of the Fed, the voice of the SEC, the voice of the CFTC, the voice of whoever who is well practiced and knows that in these sorts of circumstances, they basically need to get in a room, virtual or otherwise, a bunch of very important trading heads and say, no, the system is in place, it's well capitalized, it will survive. You all need to make sure, however, that the transactions continue. I think that's something you can't put into legislation in any meaningful way, but it's the mindset. And because financial markets are huge, they're big, they often have, and I often think of it like the Panama Canal, a shockingly large amount of volume can go through what's actually a fairly narrow channel. And if something goes wrong, then you just see catastrophe. And I think that sort of exercise is part of what's missing. And it's not technically part of the regulation, it's not technically part of the legislation, but I think it is a critical part to solving fundamentally too big to fail.
So Seth, I want to build on some of your comments and as well as Anna and Ben. So one of the, just sort of elevating to 30,000 feet, so to speak, one of the common threads that or themes that was raised in Anna and Ben's opening remarks was really the strength of U.S. financial institutions' balance sheets as a result of Dodd-Frank, and how they did an excellent job of sort of weathering the storm during the pandemic. There's been a lot of criticism surrounding the effectiveness of the Fed's 13.3 facilities and during the pandemic. And, I think that part of that is tied together, and how the Fed ultimately will define success in the utilization of those facilities. Seth, I know during your time at the board, during the last financial crisis, you helped to help build those facilities. But just trying to get a sense of the relationship between, the strength of banks' capital and liquidity positions and the Fed's sort of crisis playbook, and seeing the COVID pandemic through that lens and how those things are related.
So for me, just a couple of high-level thoughts there, I guess. One, the Fed and the Treasury working together to intervene in the liquid markets, sort of restored market functioning, credit spreads tightened, and you had trading continue. So in that regard, I think the capital strength of the largest institutions gave that little bit of cushion of time so that sort of market functioning was returned. And so I guess in that regard, that part of it, seems like it more or less went well. Some of the other 13.3 facilities, which I think of as much less directly related to Dodd-Frank type regulations. So when I think about the Main Street facility, if I was going to lay out my list of complaints about that, it wouldn't come down to capital strength of the largest domestic banks. It would be design principle of the facility. Does it make sense to have the marginal risk-taking decision be the marginal risk appetite of bank lending because they had to keep a vertical slice of risk when we're in a pandemic, and presumably the Congress put at risk $454 billion with a higher appetite for risk than the marginal risk appetite for a bank during a pandemic. So that's where I would be most upset. I don't think you're ever going to get to a point where prudential regulation is going to say to a bank, hey, in the worst economic catastrophe anyone alive has ever seen, why don't you just take on incrementally more risk in a way that you can't model and can't assess? In fact, prudential regulation would probably push you in the opposite direction. And so I'm, for me, these are mostly, not entirely, but mostly separable.
Does that, Ben or Anna, do you have anything else to add?
Jarryd, I'll add one thing. I think one thing that was interesting, I am by no means an expert on the facilities and only had a very light interaction with them. But one of my observations about them was, you have to think about what's your measure of success. It's not necessary. I don't think in the case of all the facilities, it was the uptake. There was actually some very interesting signaling effects that happened. I'd be interested to see if Seth had a view on this. Some of the markets that were sort of totally out of whack magically healed just at the mere mention of the fact that we were introducing a facility to start to address them. And so, I guess I'd be interested in the reaction of my other panelists, but I don't think as a measure of success we should, necessarily. I don't think the measure of success for every one of the panels necessarily the same. And as I just said, I know that at least in one or two cases, we achieved effects with even before we initiated the facilities.
So
I'll just add my thoughts on that. Something that people should not lose sight of is that the banking and financial systems operate on confidence, right? That your counterparty is going to be there. And so knowing that the Fed is going to be a backstop, so that if I buy an asset from you, and my worry from the financial crisis, if you think back to it, like I can't unload it. And the only way I unload it is if I sell it for 10 cents on the dollar, I'm not going to want to buy it from you. But in turn, it's a cascading effect. Then if you then can't sell it to me, then you're not going to buy it from the next person. The signaling from the Fed, I personally believe, did make a significant difference because it restored confidence that people would be willing to buy and sell assets in the market, knowing that if there was a liquidity crunch, because who knew the breadth of the pandemic and what was going to happen, that the Fed was going to step up and I would be able to liquefy that particular asset to get the cash to be able to pay my other going concern costs and expenses. I personally think that there was a very significant aspect to that.
Excellent. Rena, any final thoughts before we
Yeah, no, I completely agree with the points that Ben and Curtis just made. I mean, I think that, we certainly heard that from market participants and talking to them about the credit, the different 13.3 facilities and their uptake. And, the sort of view was you didn't necessarily need to step in and sort of participate in those facilities because the fact that they were there provided that confidence and that backstop. And I think if we just look back at sort of what, Dodd-Frank did to 13.3, the authority, and sort of trying to limit it, so that it couldn't be implemented to kind of rescue specific firms, but had to sort of be a program of broad-based eligibility. It's really interesting to then see how the Fed was able to kind of flexibly still deploy their 13.3 authority in this last crisis in a way that that still had a significant, I think, impact in terms of restoring confidence.
Great. So Anna, Seth, Ben, Rena, Curtis, Jay, thank you all for your thoughtful remarks and for taking time in your busy days to share with us and to share with Rutgers. And I guess at this time I'll turn it over to Professor Eakley.
I just add my thanks to yours, Jarryd, panelists and moderator, and thank you all in the audience for joining us for this really fantastic program.
Thank you. Glad to be part of it.
Thank you.
Thank you.
If anyone has any CLE questions, feel free to put it in the chat or Q&A. And if you have any trouble, you can always email ipe@law.rutgers.edu. Put that in the chat. I'll follow up with any of you who don't turn in your form anyway, because I've got your names, numbers. We're going to give it one more minute and then we'll close the webinar. Again, you can just email me if you have any questions about the CLE.